You're listening to Crashes, Claims, and Clarity, hosted by Darrell Burrow, a Georgia-based personal injury attorney with over 30 years of experience and founder of Burrow and Associates. With a background in both legal strategy and compassionate client care, Darrell has helped over 10,000 individuals and families navigate life after injury. Guided by his Christian faith and a deep sense of justice, he brings expert insight, personal stories, and powerful interviews to every episode. If you're looking for truth, support, and clarity in the aftermath of an accident, this is your place. This is Crashes, Claims, and Clarity.
Well, hello, everyone, and welcome to another episode of Crashes, Claims, and Clarity. I am your host, Darrell Burrow, an attorney, founding attorney of Burrow and Associates here in the state of Georgia, with our headquarters in Gwinnett County, but serving all of the state of Georgia. Today, we're going to be talking about something that people do not think about very often until it impacts them immediately after an accident. What people don't realize is that an accident for a period of time can create a great financial crisis, and that shows itself long before any type of recovery shows up. Medical bills mount, insurance companies cause delay, treatment plans become very expensive, and for many people, the stress of the finances seems to become equal to or almost more so than the injury itself. We've discussed some of these topics before with Darren, also from Gain, but today we're taking a deeper dive into what actually happens behind the scenes and what injured victims need to know to protect not only their health, but also their finances. Joining me today is Chris Conefry. Chris, thank you so much for joining me.
Thanks for having me, Darrell. I really appreciate it. And I'm happy to add to the alliteration of the title of your podcast with my two C's in my first and last name.
Okay, that's awesome. Chris is a co-founder of Gain since 2011. He has helped lead the efforts to provide financial solutions to accident and injury victims while they await legal resolutions and legal settlements. He's played a key role in helping those individuals access medical care through letters of protection, and that's when insurance does not or has not stepped in. Well, Chris, before we kind of jump into some of those issues, please tell us about your background. And as I understand it, you were in a world of finance and trading, and what kind of helped you made this leap over to helping victims of accidents and crashes and injuries?
Well, thank you for having me. And, it's an interesting story. And, a lot of things in life work out with a kind of a fortuitous, meeting by chance. And as you mentioned, I had a finance background. My partner, Reed, did as well. We knew each other very peripherally beforehand. And I was friends with an attorney just socially out of Savannah, Georgia. I was living in Beaufort, South Carolina at the time. And he had run into what were portrayed as solutions from a lot of groups to help, bridge the gap in folks that were struggling financially, typically on cases. And, 15, 16 years ago, our space in general, whether it's funding or medical funding, as we've evolved into more of an RCM platform, but those challenges were the market for solutions was not quite mature yet. And a lot of the folks didn't understand, or the practitioners doing it saw it as, in the worst cases, sort of a money grab. And we're marketing to the end user, and marketing, instead of aligning themselves with trial lawyers and trial lawyer organizations, they would market to the end user on TV commercials during the day, and really representing themselves as a financial solution when it really just made cases complicated. And when our attorney that we were mutually friends with said to each of us, you are, with your background, I run into this problem and these challenges all the time. And what I run into is that it seems like the wild, wild west, and it's almost loan shark-ish. And if I can give you a little glimpse into this kind of space, and give you some guidance. There's a happy medium here in responsibly, forecasting and underwriting cases to be that solution that helps level the playing field rather than disrupts a case getting settled. Because in so many cases, a lot of companies were just throwing money at the client and then fighting it over at the end with ridiculous 3x payoffs, and just, with many cases, lower limits lower limits cases that were challenged, which, many see on a regular basis, in our world. And so he said, if you can, use my guidance and set this up, that you'd be a great avenue to, to be aligned with, as attorneys like myself and trial lawyer organizations. And so we, took that mission in leveling the playing field for this group. And yes, there's a financial aspect to it. You're running a business, but there's a very happy medium in there in practicing and understanding the case. And when you're providing any kind of financial solution, whether it's medical, treating responsibly at a high standard of care with a reasonable fee schedule, or if it's providing financial assistance, which I'm sure we'll cover, doing that in a responsible way that can alleviate that burden of time, which is against always what the plaintiff and plaintiff attorney are fighting, versus what on the other side, on the insurance company, time's on their side. Then we can walk through the mechanics of that, and that's not vilifying insurance companies, just math. And so what we did is really did a deep dive into how this whole ecosystem works, and found that happy medium from a pricing standpoint and a solution standpoint, evolved into seeing pain points that attorneys and providers see on a regular basis, and just tried to develop a platform as we evolved over the course of 16 years to both alleviate all those pain points, be aligned with trial lawyer organizations. We're very active legislatively, and seeing what is always going to be an evolving landscape, and staying ahead of that curve from a legislative standpoint and from a best practices that aligns everyone and gives the plaintiff, the patient or plaintiff or client, the chance for the best outcome. And then in a way that can switch the side from being what was historically an adversarial business to now you're sitting at the same side of the table.
Yeah, good.
And that's
good.
the overall mission.
What are the first or initial financial surprises that you see accident victims people face once they've been involved in one of these wrecks, or an injury, slip and fall, whatever it might be?
Sure. I'll start it with a lawyer answer. It depends. So, and I only say it depends because there are so many different types of cases and burdens that people are facing. So if you have that, if you take the first statistic, and the average American has about 4 weeks of savings in their savings account. And wow. So if you take a case that is, anything from let's say, moderate impact, that impacts someone that needs, whether that's physical therapy or, maybe an ortho kind of moderate treatment, let's say an injection, but their life is disrupted from that accident, from that injury, and they miss 3 weeks of work. Well, you're behind the 8 ball on paying a bill, whether it's rent or whether it's all of your bills of any kind, whether it's household life needs. And part of the mission I mentioned earlier was addressing needs versus wants, right? And what are those life needs? Yeah. Paying bills, groceries. I would put buying your kids Christmas presents is a life need, with a reasonable amount. That's probably about as far as we would, when we set it up, would go. And so that is, on the moderate kind of impact to, then there's the catastrophic, where you have a patient or a client, and it's, there's so many, as we all know, there's so many horrible stories out there of people's lives being disrupted in a catastrophic way, whether that's, do they need in-home care? If they've become, someone's lost a leg, unfortunately, and they, just as an understatement, they might need a handicap van because they still want to work, but where the gas pedal is on the left hand, you can control with your left hand. We've done that. And that's a bigger financial need, but that can get them on that road to recovery while also alleviating that burden and not feeling the pressure of time against them.
Yeah. Yeah. And as you said, there's different cases, different challenges.
Sure.
For those that don't feel that immediately, what is the best way to educate them? I mean, from an attorney's perspective, I guess we try to do that, but how quickly would you like to become involved? And then what is the education process on y'all's end
Man, you are so spot on with that, because when I say alleviate that burden, there are so many cases where we haven't put a dollar out to this client on the funding side, right? But just knowing it's there can have them come up with that solution and manage that. And if they know that liquidity, so to speak, or that financial assistance is there when they can turn it on, and they may not have to use it, but knowing it's there just takes so much pressure off some of that urgency of maybe if there's an unreasonable offer on the initially, which happens from time to time, that they can let that case mature and get the outcome that they deserve, according to a system that works pretty well typically. But it is education is exactly what you hit on, to know that it's there, but not necessarily need to use it. And then as you can forecast that, I mentioned what the practices were in the early stages of an industry that wasn't very mature, to set both, and both in practice and both just from a vintage of time standpoint, for them to instead of saying, well, how much do you need? Okay, it looks to be like this case could be within this range of recovery. Let's give you all this money up front. Well, no, there's a mathematical solution to this. What are your monthly bills? What are your, as I mentioned, the one extreme, they may not need it, but knowing it's there is an alleviation. But I'm going to be really challenged to pay my rent, which is, make up a number, if it's $1,000 a month in 3 months. Okay, well, we can start covering that on a monthly basis going forward. So if you take that 3 months out over the next 12 months, well, you've received, it's simple math, $12,000, but the amount of time that's been out is 6 months. And so just having people understand those almost simple mathematical, with a plan, as I mentioned earlier, to be on the same side of the table as them, as a solution to help level that playing field, where they can now go on about, on their road to recovery in every sense, both financially, physically. And the practicing it that way is, you mentioned education, but doing that in a responsible way really enhances the better outcome so they haven't taken too much of a settlement up front to where it gets complicated at the end. Because I mentioned it being disruptive to a case getting settled. Well, you don't want to become part of the problem, because now if you've just allocated too much money because it becomes a money grab from someone that thinks it's a great idea for a business, well, you're not aligned anymore, and that just disrupts the whole process.
Yeah. We've heard the term, and we throw out the term letter of protection, or LOP. What does that mean, and what is that used for?
Right. So a letter of protection is essentially an agreement between the plaintiff's attorney and the medical provider for the patient to receive treatment immediately, and then with payment deferred until the case settles. And there's typically language in there that just directs the payment from the plaintiff to the attorney that says to pay these medical bills out of the settlement. When that happens in cases where clients are underinsured or uninsured. Another stat for you: 75 million Americans are either uninsured or underinsured.
Wow.
And so that is a tremendous resource, because it bridges the gap. It gives providers confidence that they'll be paid from the proceeds, and it gives the patient access to the care they need when they need it, not months or years later. That's critical for someone when they're treating, as I'm sure you know. And, in many cases, it can be the difference between someone receiving appropriate medical treatment at a high standard of care or going without care altogether. The reality is the civil justice system can take time. And, a letter of protection allows that medical care timeline to follow the patient's medical needs rather than the litigation timeline.
It seems like it allows the patient to focus on real decisions like care, instead of just having their mind focused on nothing but money, or how am I going to pay for this? And they make better reasoned decisions.
Bingo.
For sure. Okay.
Yeah, bingo. And so it allows everyone to do their job in the part of the process, right? It allows the attorney to gather all the information, get organized among the case, lets the patient get organized in a process that if we're lucky, we may or may not go through once in our lives. And in many cases, it's the worst thing that happened to somebody. So that organization and understanding their options is hugely important. And it allows and it allows doctor to focus on treatment, patient to focus on getting better, attorney to focus on getting that case organized, and a strategy in from helping the patient recover both physically and financially for whatever that's cost. And that's those metrics are driven by, could be ultimately a jury, or when it works correctly, what is essentially just insurance claim.
Do you think, and I know you mentioned, and I certainly know the legal process takes time, and it takes time to develop these cases and work them up properly. But do you think from the insurance company's standpoint that sometimes they use time delays as a strategy that they think is going to work in their favor?
I think if you look at it mathematically, right, from a business standpoint, and it ultimately, you'll see where I'm going with this. If insurance companies work to simplify it, premiums are paid, and that money goes into an investment arm of the insurance company, where their benchmark is, trying to realize a certain interest rate, right, or a certain return, right, because that's a responsible way to run a business. So time is automatically your friend, right? And so at its worst, yes, absolutely. Do I think every adjuster walks in there and gets in there, goes to work every day and says, let's drag this out as much as possible? I hope that's not the case. But by the way it's set up, how can it not be? Right. And so time is, and then you have the court system, of which, ultimately is, if you want to say preserving I think it's the Seventh Amendment of, right to a jury trial. Well, those take a lot of time if it eventually gets there, to be, a result given by, a jury of peers. That if that is, and then you take the criminal, you take the court docket, criminal cases get first. And then there's probably civil, and then family law, those, the urgency of what is considered urgency. And then those personal injury civil cases are, how hard is it to get on a trial docket, right? And so that is, that can be a year, 2 years, 3 years. And so time is automatically on the insurance company side, just mathematically from a business standpoint. And so, if you look at and I'm not trying to vilify anything, but if you look at like the BP case from many years ago, and they set aside, I think it was $12 billion, and that took north of 10 years to start to unwind and settle. So if you're earning 8 to 9% as the investment arm of that insurance company, after 12 years, you've made back that 12 billion. And it's not even an impact on their balance sheet.
Right.
It's, you've created that reserve, and I'm not in finance of an insurance company, but I think it's a reasonable assessment of it. And so that is the finance or business variable that automatically makes the longer time cases take to resolve them benefit. That was as diplomatic as of an answer I could give you.
Yeah, no. Everyday Americans that are hurt from an automobile crash, what mistakes do you see them make when it comes to picking a medical provider, and how does your company specifically assist in preventing those people from making those mistakes?
Right. So, if you take the ecosystem at its worst, right, you have lead generation companies, which, at its worst if it's a search engine optimization, mechanism they use, a lot of times that's blurred the lines of, bad practices by attorney's office, which are, runners or whatever that is. I'm saying the very worst. I'm not accusing it, this on a large scale, but what that evolves and extrapolates into is, now when you talk about being aligned, there's people aligned in the wrong way. And there are groups of attorneys that are just looking to sign up as many cases as they can. At its worst, have providers that are known to be shills will say of plaintiff that don't have a standard of care to that is, that have a doctor that say you and I could go to. And standard of care is a huge part of our mission, we'll say, everybody, we make it especially part of ours to find that access to that standard of care that is, as I said, that you and I could go to, that is not just a large scale, whether it's up the chain of any modality, if it's, anything from imaging, pain management, physical therapy, if it's based on attorney directed care, there's a fine line there. Now, at a high level, attorneys that treat injured people or injured people are probably going to meet a doctor at some point in their life and know a good one. But when it's directed from a standpoint of, and I think this is what pisses adjusters off so much, as in part of the conversation of where tort reform comes, is when you're treating the bill and not the patient, or the limits and not the patient, right? And you can easily wind up in the wrong hands from a provider. And we make it very incumbent upon ourselves to be that, source of expertise of knowing that working with folks with that standard, providers with that high standard of care, again, have access to that you and I are so, you and I would have access to. And that can be the biggest mistake is, getting in the wrong hands, both attorney and provider wise, where you don't have that standard of care. As I mentioned the adjusters, and what happens is then if the limits are 25 and then there's miraculously $32,000 of treatment, and the provider says, well, I can reduce this bill, no problem. Well, you're treating the bill and not the patient. Now, many times cases of the medicals are more than the limits, and that's, that happens in commercial insurance as well. You want to understand their options. That can happen. But when it becomes a trend, the correlation between standard of care and practices among that attorney directed care and that being in this sort of, in cahoots almost network, there's a high correlation between those two things. And that's the mistake most people want to avoid.
Can you explain what medical liens are? Do they differ from what we've already talked about, the letter of protection? And how do they affect a recovery down the road for the injured party?
Sure. In practice, there's a lien is a formal way to file a medical bill with an insurance company. With just I'm going to affect this lien. A letter of protection is agreement between patient, attorney it's really an irrevocable letter of direction that just says, I'm directing you to pay this medical bill out of my settlement. Now, a lien formalizes that because you're affecting it with insurance company. It's a lien just like any other lien, if it's, whether it's real estate or whatever. And it's not it sounds maybe a little more draconian, but when you're talking about a medical provider that, like, let's say, when you apply the law of large numbers, there's probably a little bit more of a measure of protection with a lien. And not to use the word protection with a letter of, confusing it with using a letter of protection. But when if you're just a bigger practice, let's say you're in multi-states, and it's one mechanism to use as to really a lot of times just keep track of all those invoices out there, so cases aren't settled and dispersed without that medical treatment being recognized. It doesn't necessarily mean I'm going to affect this lien and I need 100% of this bill and I'm going to fight over this, and this case is not getting settled until I get paid this. It doesn't necessarily mean that. It has a little bit more of a draconian sounding name to it, or turn to it. But when cases come time to be resolved or settled, if you look, I talked about the law of large numbers, and if you say the average reimbursement rate, and I'll give rough numbers, is among medical bills across the country is probably about 40% of what commercial insurance pays. And in PI, it's probably a little higher. It's probably 50 to 55, but that's because of the time value and the duration that's out there. And I think when if on the defense challenger wants to say, well, that's a higher collection rate because they think that's a money grab against PI. It's not. It's just factoring in that duration and period of time.
Okay.
It's not 55% of collections because bills are inflated. If bills were inflated, then the 40% would be then on commercial insurance, that would mean bills are inflated. Now there are certain providers and hospitals or whatever it is that where there are, people can argue usual and customary charges, but there's a standard for that. And that, is system wide, and that collection depends on geographic location. It depends on, what type of treatment. If there's certain doctors are higher sometimes. If you've got a double board certified doctor from Cornell, if you're looking for a spine surgeon that's going to just, put something, cut open your back and cut your spine, you're not looking for a Sunday coupon. But you're not, as long as that remains within the parameters of, yes, certain doctors are higher or have higher pedigree, and there might be some price differential in that.
Right.
But
right.
it remains within parameters of usual and customary. And when you put that against when comparing it, whether it's in that geographic area or nationwide, there's a very simple mathematical explanation for that. But it is, it's easy sometimes, and you see it every now and then. It never means that bills are inflated or anything sinister that can sometimes try to be spun when maybe the facts are against somebody.
Understood. How important is all of the documentation, be it medical or otherwise, and how does your company assist with that?
So we house all bills, notes, and records in our platform, in our portal. There's two-way facing, giving access to both attorneys and providers. And I use the term being organized, right? Helping that patient get organized and understand all of their options. And that documentation of all of that in a timely manner. If you look at the organization of it from an attorney standpoint, they're going to want to understand what these medical bills are, because it does become a factor in what the impact of, what the actual medical impact was for this client on when they're evaluating their case and understanding what the value of a recovery claim is. And so the timeliness and organization of that is critical, because when it's not organized, it's a really bad look, because then, in the example I used earlier, then could be mistaken over treatment. If you've got a pain doctor that's on call at 6 different hospitals in addition to their own practice, they may not know that they're over treating someone. They know that and when I say over treating, I don't mean that in an intentional way, but when it's organized where someone just says, okay, I'm going to physical therapy over and over again because this is what I feel like I'm supposed to do, they may not know. And now there are 20 pre-surgical physical therapy visits, and someone might say, okay, did someone not maybe try an injection after some point?
Mm-hmm.
So the organization of that is hugely important, because it's responsible treatment that's the end goal, is that best high standard of care, and then organization of that treatment, and then the documentation of that as well, bills, notes, and records. And that way, when that's organized and that doctor's getting deposed, and it's maybe a little self-serving, but for me, I mentioned attorney-directed care, and it says a little self-serving in that if we're doing our job right, we are a third party that can do anything from coordinate care, manage those case updates. The doctor doesn't know what the insurance limits are. We're just managing the collections and the treatment and helping that patient understand their options. And so all of that being documented and responsible on the front end, rather than reactionary on the end, saying, oh, well, shoot, we didn't know about this physical therapy bill, and now there's, like when I used the example earlier of there's $32,000 in treatment, when it could be just from lack of organization.
Mm-hmm.
So it's hugely important. And I think, I talked about sometimes when the system, doesn't work well, but when it does work well and there's a claim to be realized and paid by an insurance company, if that's organized, that sets the conversation, it makes the conversation, has to make it go a lot smoother.
Yep. Yeah. Housed in one place that's a tremendous asset.
It is also, because then the left hand always knows what the right hand is doing.
Yeah.
And then if that physical therapy group refers that to a doctor up the chain for further treatment, everyone's aligned and the continuity of care is maintained, as well as again, at a high standard of care. And it is just, or the word I used earlier is organized and responsible, and best practices are, on all levels. And that alleviates both, in the best cases when it's an amicable, unfolding of an insurance claim to be, it can shorten the time, again, alleviating that financial burden. And then if it becomes acrimonious for both sides, it limits the ability to maybe create a sideshow for when the facts are against someone, on the defense side. Maybe not a sideshow, but the ability to say, well, this treatment wasn't very necessary, or which they should do if it wasn't.
Yeah. That's it. I akin that to poking holes in the dam. It's holding the water, which is holding the case.
Right, exactly. And then, when that becomes, and then when treatment is being, even scrutinized or questioned or just, wanting to be evaluated, that allows all of that to be in such a orderly way. It just alleviates the conversation for anything, or alleviates the process. And again, can shorten, just alleviates the burden for the plaintiff ultimately,
Sure.
or the patient.
For an injured party, and they get some period down the road and they see these bills just mounting up and piling up, what's some practical advice that not only Gain, but we as plaintiffs' attorneys could give to those injured folks?
To give to those injured folks, you would, as those bills are mounting up, understanding their options is the critical part of that. And if and I mentioned the example earlier, if you know that you have access to capital, liquidity, whatever you want to call it, a financial alleviation of what these circumstances are causing you, then it lets you stay ahead of it and not be reactive and say, now my bills are upset. My house is it's a fire drill at the end, or, at some point during the process, because I didn't understand the options, and now I'm 3 months behind on rent. And, from a medical bill standpoint, when I mentioned it orderly, if they're piling up, when it's organized like that, you can run into a situation where, let's say there's 100,000 in limits, and there's been treatment to the tune of, make a number up, $30,000. But doctor responsibly says, you're going to likely need this surgery, but it's going to cost $65,000. Getting the medical bills up to $95,000 on 100 limits policy of, understanding those options, just like commercial insurance would. The doctor can now say, there's so many doctors out there at a high standard of care. There's an altruistic nature to it. Lawyers do pro bono work, so do doctors. And in that scenario where you're going to need this surgery, but here's what I'm going to do. The invoice, usual and customary, is $65,000. I'm going to take a larger reduction on this. And in this recovery, I want you to take $2,500, and I want you to buy health insurance, because this is going to affect you 3 years down the road. That is, and I mentioned the term before, treating the patient and not the bill. And if that wants to be challenged, please challenge that. That is a doctor. Right. There's an altruistic nature to that in trying to help someone recover, both physically and then financially. And it is, when I said the road to recovery, that's the best outcome in a situation that can be complicated.
And anticipating their needs and how's it going to get paid for down the road.
Exactly. And when you're looking ahead like that and saying, in this example, saying I've got, and now you're going to need health insurance. Well, that's one less health insurance, medical or American without health insurance is one less without health insurance. And their road to recovery is now, Humpty Dumpty is now getting put back together, so to speak, and hopefully they don't have any issues with it going forward. But that's when I use the term being aligned, that's when everyone's aligned in a responsible way, which levels the playing field, which is, a term I've used a bunch.
And until the injured party is educated properly, like we've talked about, what do you see as the common myths or misconceptions they have about, how fast this process is going to happen? What have you heard during conversation?
Yeah, I think, when you see the, something when you get into like the advertising, right? And, you get some attorneys out there that are holding up a check with someone that probably just had a spine surgery and it's like they want a sweepstakes. And I feel like that can add to sometimes the perception of I'm going to sign up with this attorney. We're going to meet in a boardroom with the insurance company and we're going to, beat them down. And this is going to be a very quick process. And it doesn't work like that because treatment unfolds over a period of time. You might have to, we're going to try physical therapy. Okay, that didn't work. Let's take 2 weeks and then we might try an injection or there might be a new radio frequency ablation, whatever that is, whatever that treatment is, but that takes time. And then you couple that with the justice process or the civil justice process. And if this is not being resolved, it, in so few cases go to trial, it's, there's such a low number. But if that is the ultimate potential, again, managing, with the time on the other side, then, understand whatever you think, it's probably going to take longer. That's a great, I think, methodology to use because there are so many different, and then if you add layers like policies and process that is, just again, adds to time, that is a misconception also. And I use the example about, maybe the misconception being drawn by the holding up the big check. It's not all by that, but it's a long road. And that I think the misconception sometimes can be just as a human being, you just want to get better and put this behind you. Yeah. So that really contributes to it. I think it's just wanting to move on. And then I've got, okay, well, now treatment's done and now we're going to talk about a mediation. Now we have to get that scheduled. Now we have to, now we're going to start this process of evaluating all these medical bills. And I think that's where it becomes, there's an element of a relational aspect between when the good actors on the plaintiff side and on the, let's say, adjuster or defense attorney side, that's when it's done, tying it all together, when it's orderly, and that can shorten that time because it's, the treatment was responsible. And, insurance companies, and when talk about good actors, okay, let's pay the claims and let's move on. Those are all working people too, and they want to, remove the backlog of things. And so when it's done responsibly, that really helps that.
Yeah. Looking ahead, what do you see as far as changes in healthcare access, insurance, funding that's going to impact folks in the future?
I think you've got the pendulum that is swung to the other side. You've got tort reform, right? That has been, in many cases, a myth created. The three largest carriers had combined profits of $10 billion. So I don't think we were ready to host any telethons for them quite yet. But are things like when you talk about tort reform, and I've talked to defense attorneys from time to time, and there's reasonably intelligent conversations you can have. And, let's say it's SB 68 with the negligent security claims. If there's a CVS in a neighborhood that doesn't have a lot of crime and something horrible happens, should they be on the hook and have so much exposure? It's probably a conversation you can have. But some defense attorneys have said to me, I'm all for making someone whole. Creating multi-generational wealth is, something that maybe we could put some guardrails on. Okay, you can probably have that conversation too. But it's really hard to put caps on things because someone's going to get, if you start trying to make a uniform solution to, let's say, putting caps on damages and, in certain groups, that's a really dangerous road to go down because then someone's going to be someone's life is really going to be ruined from that. So in looking ahead, I think, you've got I mentioned earlier about, that the bad part of the ecosystem, bad actor part of the ecosystem, HB 34, H 44 is being signed into law that makes, using runners and the like a felony. I think that will relegate the bad actors into its own little side group that is really ostracized. And so I think I'm optimistic about that. I think that as long as, doing things, being aligned the right way and acting in best practices, and whether it's funding, whether it's medical treatment, treating at a high standard of care with usual and customary fee schedules. If you take it to funding, if you're doing this in a way that is truly leveling the playing field and not a money grab, then at the end, like, the system works. When we talk about in that giant middle, there's fringe zealots on each side, right? There's the plaintiff attorneys that think the big bad insurance companies and everyone's hurt and everyone deserves way more than they probably do. And then on the defense side, you've got the zealots that think nobody's hurt. But there's a big middle in there where the system works. And when going back to tort reform, when you talk about, oh, well, nuclear verdicts, or, well, you could have paid that claim 2 years ago and not, or tendered the limits. And then a jury of peers said this is absolutely absurd and awarded, hearing every detail of this particular case, and awarded, something accordingly to them. 12 people usually get it right. Of course there are outliers. There are, let's say, nuclear verdicts or whatever that grab a headline. But if you go back and really deconstruct whatever evolved, it's usually something that was pretty, catastrophic or horrible circumstances, and a lot of times egregious behavior. And it gets simplified in the headlines sometimes, but I think better practices, and having all groups in the entire ecosystem act responsibly. And as I said, that can be, if the bad actors are relegated to one certain little part of it, then that's the best chances for the system working. There's going to be overcorrections here and there, state by state. And, and then the reality is there's a big lobby on the insurance side. But when it comes to this entire space, it's not when you come to the legislative side, it's not a left or right issue. I mean, it is, it's got, if you want to just use Republican virtues, there's accountability. They can get behind that. And on the left, we'll say there's a leveling playing field for the folks that have been through something horrible, and let's make sure they're represented. There's advocates and the access to care and treatment and mechanisms if it's going to be a fight, to give them a fair fight. So when everyone's acting accordingly in that big old middle that I just mentioned, that's the best chance to not have those overcorrections on a legislative level, and reduces those ridiculous headlines.
Yeah. If you could leave our listeners with one thing they should remember about the financial side of recovery after a wreck or an injury, what would that be?
Well, when you say the financial side of a recovery is meant in a couple different ways. It's physically, for what you've been through. And if it's financially, it's alleviating that burden along the way and putting you back together for, let's say, the pain and suffering element to a claim or a case. And expectations, someone once told me that any conflict that's ever arisen has been born out of misaligned expectations. And aligning expectations for not letting that turn into, if plaintiff says, well, I've been hit, so now I'm going to I'm deserving of $1 million. Because, sometimes in the marketing or the misguided perception of this entire space, we'll call it, that can lend itself to that way of thinking sometimes. So you hit the nail on the head when you said recovery. The road to recovery. What are you recovering, both financially and physically? And that recovery can mean, if it's life-changing and there's a horrible, if there's a death, that recovery gets bigger and bigger because of the disruption of life. If we lost a loved one, then that's going to be a bigger recovery of part of the conversation. And if it's something that, thankfully was an injury or is a broken leg and that can heal. Well, that recovery is okay. Well, how much was this disrupted? How do we quantify that?
Yeah.
And the more ability you have to quantify that with all those layers of expertise along that whole process and using the right ones can greatly align those conversations or those expectations from someone that's been through something that disruptive.
That's spot on. Good stuff. It's really been valuable today, Chris. I appreciate you joining me. Very valuable. Appreciate your time and certainly your expertise on these issues. If you would, please tell the listeners where they can find out about your company.
Well, they can find out about us. Our website is just gainservicing.com. And, I think if we're doing our job right, those that are, within this, have any kind of affiliation with, trial organizations or medical providers. As I said, if we're doing our job right, we try to be pretty visible, whether it's LinkedIn or my contact or any, we're pretty easy to find. And so, and it's even if it's for just something educational, we're happy to, walk anyone through that, whether it's on the attorney side or anyone that's just plaintiff wise or someone that's wants to know more about the entire world that we navigate through. We're always happy to help because that, educating that and, can lend itself to all the best practices we talked about. And, it's really important to us, as far as, not deviating from that standard that we all want to practice under, because that's what lets that system work.
Right.
And so, I really, I appreciate you giving me the time. I think what you're doing is great. I think it's, keep doing it. I want to get my background a little cooler like yours is. You look like I look like I'm in a location, an undisclosed location for my safety. But I'm in Atlantic Tech Village. That's the A back here. But I really appreciate you. These kind of discussions are the type of stuff that lends it to that, and just keep doing what you're doing.
I appreciate you, and thanks to everyone for listening to Crashes, Claims, and Clarity. If this episode has helped you better understand the financial side of injury and recovery, be sure to subscribe, share this episode with someone who may need it, and please leave us a review. And until next time, thank you very much. Bye-bye.
Thanks, Darrell.
You've been listening to Crashes, Claims, and Clarity with attorney Darrell Burrow, founder of Burrow and Associates and a trusted advocate for over 30 years. If today's episode helped bring clarity or hope after an accident, be sure to follow, subscribe, and leave a review. To connect with Darrell or learn more, visit legalatlanta.com. Join us next week for another honest, faith-centered conversation about recovery, rights, and moving forward after injury.